Attorney Fowler, I've heard that someone could give away $14,000 a year. Is that true for Medicaid planning purposes?
What you heard is correct in the first part of it. Under the federal transfer tax law, which is a state and gift tax law, there's an annual exclusion of $14,000 per donee. Each taxpayer can give $14,000 to as many donees as they want without even getting into the tax system. That's their annual exclusion. So you could give away a good bit of money. A family with 5 kids, husband could give away $14,000 a year to each child, and wife could give away $14,000 a year to each child. We used to worry a lot about maximizing the annual exclusion. We don't anymore because of the $5+ million exemption. But that's an exemption for gift tax purposes. There is no exemption for Medicaid purposes. That's a little bit too broad of a statement. There are some exemptions, one of which, a big one that I mentioned in answering another question, is that transfers to a spouse are totally exempt. But what people many times are doing is thinking about transferring to their children so that they can become qualified for benefits. And the only real exemptions to that are transfers for a disabled child can be exempt. Many times when we use that particular strategy, we generally want to use a trust for the sole benefit of the disabled child, because otherwise, if we just transfer directly to the disabled child, then those assets are potentially subject to the creditors of the child or any other problems that the child might have, including not taking care of mom and dad anymore after the transfer. Otherwise, we kind of focus on the word transfer. And some of our strategies, a transfer is a non-compensated transfer. So sometimes we transfer in exchange for services that the child might render, oftentimes using a personal care contract or personal care contract trust. And that is not a transfer for no consideration. But generally, if we do have any transfers and there's a 5-year look back to whereby when you apply for Medicaid, the government can look back 5 years, and if they see any uncompensated transfers and non-exempt transfers in the 5 preceding years, then you're going to be ineligible for Medicaid for a period of time equal to dividing the transfer by the penalty divisor, which is an amount that is adjusted by the state every year, and it is supposed to be the average cost of a nursing home in Florida. And at the time of me speaking here in 2014, that is $79.95, which is $7,995 per month. So, if you transferred $80,000, for example, to your child, that would be an 8-month penalty period during which you would be ineligible for Medicaid. And what we do is we look at ways to cure the penalty. Mentioning this also brings about the concept of advanced planning. Many times, if the health and circumstances of the client dictate, we can transfer assets to an irrevocable trust, and once 5 years has passed after transferring those assets, then those assets are no longer considered as available for Medicaid purposes. So oftentimes we can use that strategy as an advanced planning technique. But we also need to keep in mind our crisis planning techniques. And if we use that as an advanced planning technique, then depending upon how long we make it, then we might have to do some other strategies to fix the trust if we don't make it through the 5 years.